Good afternoon, Your Honors. I'm Kimberly Wittenberg-Lurie, and I represent the appellant, Mr. Joseph Lee. May it please the Court. I think this case, in its simplest way to look at it, is that the Commonwealth failed to prove their prima facie case for operating after a suspended license. What happened in this case was, well, let's just go back to what they would have had to prove. But they would have needed to prove that Mr. Lee was driving. They would have needed to prove that his license had been suspended. They would have needed to prove that, the Commonwealth would have needed to prove that one of the enumerated offenses was within Section 23, okay, the triggering offense, and they would have needed to prove notice, that he had notice of this. So looking at this, as far as whether, and we can look at this, my second issue in my brief, which is whether or not the enumerated statute is included. There's a previous offense in 2007 where Mr. Lee is arrested and convicted for operating under the influence in Massachusetts. There is subsequently a 2008 conviction in New Hampshire, okay? The trooper testifies that Mr. Lee, when he talks, when they have their conversation, when he's pulled over sort of randomly on his way to work for operating without a license, he says, oh, well, I did have this New Hampshire conviction, but I didn't know my license was suspended. So while Mr. Lee never testified, that is in the record. So we then look at the enhanced penalty. So I think where the Melendez-Diaz objections, trial counsel objected numerous times to the evidence coming in, meaning the RMV certificates, the RMV certificates. And those objections were overruled. And I think at that point, trial counsel's best strategy was to go for the enhanced portion of the statute. And I think that the arguments made were very much saying, hey, the New Hampshire law isn't anywhere enumerated in here. Why are we sentencing on this? Okay, it's clear. And it's interesting because as I reread the transcript, I think it's like a 27-page transcript, the judge even admits at one point that it's really not clear, okay, but that this is how it's been done. And the way the Commonwealth argues that it's sort of being swept in with 24, with that previous conviction from 2007. But for the New Hampshire conviction, his license wouldn't have been suspended at this point, okay? The Massachusetts one from 2007 was a 45-day suspension. That happened, he served that.
Is it an OUI?
It was an OUI.
So why wouldn't that qualify under the third paragraph of 23?
Well, my argument is that the triggering event, the one that caused the license suspension, okay, was a New Hampshire conviction. A New Hampshire conviction happened in 2008, okay?
I know that. I just don't know why either one of them wouldn't have done it.
Well, I think if you look at the third paragraph now, because it's been amended, of Section 23, right, it goes to great pains to very clearly spell out the different things, you know, the different statutes that will lead to that. It talks about 24(1)A, obviously. It talks about 24D, 24E, 24G. It spells it all out very clearly what's going to be included. Nowhere in there does it have that key phrase, oh, in other jurisdictions. And I think it's relevant because a lot of the cases that are cited by the Commonwealth have to do with the compact between the states about suspending and revoking licenses. It's a very different case, though, where we're talking about enhancing sentencing, okay? It's not just about, I mean, I don't think we're even contesting that his license was suspended. I'm contesting, number one, that he had notice of it, okay? And number two, that New Hampshire statute, or the New Hampshire conviction should not have triggered
Wasn't
this.
the 2007?
Massachusetts.
Right. That's under 1A, isn't it?
It is.
I'm just lost as to why that couldn't be the triggering event for the suspension.
Because his license was back. He wouldn't have been operating without a license.
I see, I get it.
He wouldn't have been
Okay,
operating.
I get it.
Right, okay.
It had been restored?
It had been restored, and then he had another OUI conviction in 2008 in New Hampshire. And then sort of my argument is that Section 23 shouldn't have this authority unless it's I mean, this whole narrow construction of statutes. If we want other jurisdictions, so many of the other statutes go to great pains to say, oh, in other jurisdictions, this is how all the OUI ones pretty much say that. In this one, it's sort of just swept in there with 24A1. And we're talking about liberty. We're not talking about suspensions of licenses. We're not talking about revocations of licenses. We're talking about an enhanced penalty going from 10 days of incarceration to 60 days of incarceration. All right? Going to my second issue concerning whether or not he had notice. My brother at bar talks a lot about objections, general objections, specific objections, whether this objection is enough. It was objected to. Melendez-Diaz had been decided. Parento had not, okay? So I think trial counsel was doing the best he could to try to keep these RMV certificates out. And I don't think the dust had settled yet completely on Melendez-Diaz, and he didn't know how far it stretched or what, but this was sort of his best try at keeping the RMV certificates out. Now, we come to learn that Parento lets a lot of it in, but it doesn't necessarily let notice in. There has to be something special for notice. So with that argument, I don't think the Commonwealth proved their case. There needed to be notice. And if we look sort of retroactively now, notice wasn't proven because those RMV certificates shouldn't have been let in. Now you can say, well, the objection wasn't specific enough. There was no Parento case to be specific. There was a Melendez-Diaz objection, and that was, I mean, I don't think that's particularly general. I mean, I've gone to enough trials and heard, I object. You know, this is a Melendez-Diaz. There was clearly, they were saying that this was not a sufficient offering of proof. So for these
Was it clear that he was objecting to the admission of the registry documents?
Yes, not specific to notice. I'll be very upfront with you. It's not notice, and there's points in the trial. I just want to lay this out because I'm sure my brother will. That trial counsel, in his argument, says, I know he was driving with a suspended license because he was driving with a suspended license. That doesn't mean he had notice. He knew he had notice because he elicited in cross-examination of the trooper that, in fact, he didn't know his license was suspended. So whether it was not artfully, I'm sorry.
I guess what you're saying is, what else could he be referring to but notice?
Well, I think, you know, I'm going to just be really clear. I think he was objecting to the whole thing coming in, and notice was a piece of that. Because if you throw out those RMVs under Melendez-Diaz and he was able to get the whole thing out, all you have proof of is my guy's driving.
It's because it was pre-Parento, so he could legitimately make that argument. It had not been decided
It hadn't
that
been
pieces of
decided.
it would
So his
come in.
Melendez-Diaz objection really isn't that general, and that, I mean, I think it's pretty specific. Are there any other questions? Almost. Thank you.
Thanks. Good afternoon. If it may please the court, my name is Daniel Herron. I'm an assistant district attorney for Middlesex County. I represent the Commonwealth of Massachusetts in this matter, and I was also the trial counsel. I think specifically to differentiate this case from Parento, in Parento there was a very specific objection with a motion in limine in which the trial defense attorney requested that the attestation concerning notice be redacted. Here, there was no motion in limine, and I'll get to it in more detail in a moment, but actually there were no motions in limine at all. And during defense counsel's opening statement to the court, he stated, I'm not disputing that he was operating on a suspended license, and that appears on page 5 of the trial transcript. The differentiating thing to this from the drug certs and the other litanies since Melendez-Diaz is that the courts were bound by this court's decision in Commonwealth v. Verde. The argument that Parento wasn't there is different than the analysis post-Melendez-Diaz because the courts and counsel were bound by this court's decision in Verde. The court here and the defense attorney here was not bound by that. And so it was possible for the defense attorney to specifically object to notice because that was done in Parento. So in that sense...
Well, before Melendez-Diaz, there were lawyers making objections that turned out to be correct. I mean, I'm not sure that, well, I just don't think that, yes, he could have. The question is, did he need to?
I think he did because as this court said in Parento, and as the United States Supreme Court said in Melendez-Diaz and in Crawford, that business records are still admissible and they're not testimonial. And as this court said in Parento, the RMV records themselves, the notices, the letters of notices are not testimonial. The only aspect that was found testimonial by this court in Parento was the actual attestation regarding notice. So Judge Rooney, who was the trial judge in this case, was correct and correctly overruled the General Melendez-Diaz objection. At trial, when the Commonwealth sought to introduce the R&V packet, which did contain the attestation and the certification that they were kept in the ordinary course of business, he said, I'm objecting on Melendez-Diaz grounds for the record. Didn't say notice, didn't say the driving history, didn't say the letters. Judge Rooney was correct in admitting the records for the driver's history and the letters, as this court said in Parento, as they are business records. And because he didn't specifically point his objection to the attestation regarding notice, regarding mailing, Judge Rooney was not put on notice that he had a grievance with that he was saying, Judge, it's the specific thing that I believe violates my client's constitutional confrontation rights. That was done in Parento. So it was certainly, he had the ability to do that. And again, to differentiate this from the drug cert analysis, Judge Rooney nor the defense attorney were guided by this court's decision in Commonwealth v. Verde. As a result, the standard of review here should be a substantial risk of a miscarriage of justice, not the harmless error standard.
The so-called certification, is it on page 33 of the record? Appendix? Did the certification say that these were mailed or simply, here are copies?
The attestation did say that they were mailed. It was the same attestation that this court considered in Parento. And then separate from that was a copy of the actual letter that was allegedly sent to the defendant that included both the Massachusetts and the New Hampshire conviction.
So there was a certification done after, for purposes of prosecution, saying these were mailed,
Yes.
as opposed to any record on the mailing itself to reflect that.
Right,
Yes.
it's in the first paragraph there.
Because we need to review this from the substantial risk of a miscarriage of justice and not harmless error, the four analysis that the court has laid out, in particular, the basis for whether or not the admitted evidence materially influenced the case. And I think that this gets into what counsel touched on in her argument, was that defense counsel did concede it. As I said before, in his opening statement, there were no motions in limine regarding the admissibility of these particular records. Counsel said, I'm asking that you find him guilty, and I'm conceding that he's guilty of operating on a suspended license. But he said, and which turned to be what was actually disputed in this case, that the Commonwealth would not be able to prove the enhanced portion relative to the basis for his suspension. So as counsel argued to the court a few moments ago that as a trial tactical decision, he conceded the lesser included offense, so to speak, as a result of his motion or his objections being overruled. That's not the case. He conceded it from the outset before it was raised. During the short trial, when the Commonwealth sought to introduce those records, that is then when he objected. But then going on beyond that, Judge Rooney, during his argument on the motion for required finding, brought up the issue of notice when they were talking about what was contained on the actual letter, and he stopped her and said, right, I'm not arguing that. I concede. I'm asking that you find him guilty of operating on a suspended license, but not find him guilty on the enhanced portion. That appears on page 14. Then again on page 17, he reiterates that fact. So under the substantial risk of a miscarriage of justice, Judge Rooney raised the idea of notice, and he just categorically said, I'm not arguing that here. That's not the issue. Under harmless error analysis, we would look to where the premise of the defense was and what actually influenced the verdict. And here, based on his arguments in opening and in the motion for required finding, the Commonwealth submit that there is no substantial risk of a miscarriage of justice.
Or harmless error,
Well,
or the error was harmless. Did you just say you were looking under both standards?
no.
Okay.
I would say that the standard to be applied here is substantial risk of a miscarriage of justice
Explain that again to me, why that's the right standard of review?
because the error was not preserved. The objection that was made by
Let's
trial.
assume the error was preserved. The
It-
objection was preserved. Let's say that the objection was specific enough.
If that's the case, then it would be harmless error, and then parental would control. And I think that this court would be bound to find that it was not.
It would be harmful error.
Yes. But because the error was not properly preserved, because the issue was not brought to Judge Rooney's attention, the Commonwealth would submit that the analysis should be substantial risk of a miscarriage of justice. Moving to the second issue, specifically, the defendant, the RMV suspended the defendant's license pursuant to General Laws, Chapter 90, Section 24(1)(c)(2). 1(c)(2) requires the RMV to suspend someone's license when they are convicted or assigned to an alcohol treatment offense, and they've previously been convicted or assigned to an alcohol treatment program for OUIs. In this case, as counsel pointed out, as is in the record, the defendant was assigned to an alcohol treatment program for a continuation without a finding on a Massachusetts OUI in approximately 2007. Then more recently, he was convicted in the state of New Hampshire. The Commonwealth would submit that the registry did suspend his license pursuant to a Chapter 90 offense because it did so under subsection 24(1)(c)(2), taking into account both the New Hampshire as well as the Massachusetts OUIs.
But 24(1)(c)(2) isn't, I don't think, mentioned in the third paragraph of 23.
Third paragraph of 23 is conviction 9024, so an OUI offense. So the
But
2007.
right, that one works, but that isn't what he was, that wasn't the license that he was driving, that wasn't the suspension that he was driving under at the time.
But if he didn't have the prior Massachusetts offense, then the registry would have suspended his license
No,
under
I understand that,
24(1)(c).
but I think her argument is, look, you've got to look at the language of 23, third paragraph, very precisely, because it's a criminal offense. I don't, and it mentions paragraph 24A1. The New Hampshire conviction obviously wasn't under our Chapter 90, Section 24A1. So I think that's the point.
Right, but he wouldn't have been driving under a suspension at the time because he would have only received a one-year suspension. If he didn't have the Massachusetts offense, his license would have been suspended for 1 year under 24(1)(c)(1). Because he had the prior Massachusetts offense, his license was suspended for 2 years, not for 1 year, because the RMV took into account that. So it was a suspension pursuant to a Chapter 9024 offense, his 2007 Massachusetts offense, as well as a suspension pursuant to his New Hampshire offense that came later. So because he had the prior one, the RMV did have to suspend his license pursuant to a Chapter 90, Section 24 offense.
That just affected the length of the suspension.
Yes. But his license would not, I don't remember the exact dates, have been still suspended. So because the length of the suspension, it's still a suspension pursuant to the earlier offense in
But that's
conjunction with
just,
the later one.
22 is not the same thing as 23. I mean, 22, it goes to the registrar of motor vehicles and tells the registrar of motor vehicles what to do. It doesn't seem to me to have any impact on whether or not the statute, Section 23, it's an enumerated offense or it's not.
You're making, I think, is this what you're saying? That you because he was still under suspension when this happened, he only could have been under suspension, really, yes, it's more directly because of the New Hampshire, but it's really because of that 2007 conviction, that's what makes it be able to be 2 years, right?
Yes.
And so it is a conviction under, a suspension under 24A1. That's what
Yes.
you're saying. So you're
Yes.
going back to the 2007.
Yes.
Okay.
Did the judge hear evidence as to the New Hampshire law that would have allowed him to make a finding?
If I understand your question correctly, there was no evidence regarding New Hampshire law, but there was evidence of the New Hampshire conviction that was introduced at trial.
How would the judge be able to make a finding that this was pursuant to Section 24A1 without knowing that New Hampshire gave him a longer suspension because of that violation?
It was our registrar that suspended him because for the suspension, they can use the New Hampshire, right?
Yes, and that would be, as Justice Lank was starting to point to, Section 22 mandates the registry to treat out-of-state the same as in-state. The issue for the criminal statute for Section 23 being strictly construed against the Commonwealth, that's the argument with 24(1)(c)(2). In terms of the New Hampshire offense, in that colloquy that I referenced earlier where Judge Rooney was asking defense counsel about the issue of notice, she was referencing the actual letter of notice of suspension that the defendant received that said your license is suspended because of your Massachusetts offense and because of your New Hampshire offense. So in that colloquy with defense counsel, she actually said, I find that it is suspended pursuant to Chapter 90, Section 24 offense because the R&B specifically said they suspended it taking into account the Massachusetts offense.
Okay.
I know that I'm out of time, so if there are no further questions, I thank the court.
Thank you.